major Supreme Court decision today, for the first time extending protections against discrimination in the workplace to sexual orientation. Joining me to talk about this ruling is Kristan Peters Hamlin, a former federal prosecutor and a current employment law litigator. Kristan, thank you very much for joining me. Let's get right to the decision for a second and exactly what it was all about. This was not a constitutional decision. This was a decision interpreting a statute that goes back 56 years. What did the court find?
So this was a combined appeal, 3 cases from 3 different circuits, 11th, 6th, and 2nd circuits. And 2 of them have to do with sexual preference discrimination, and 1 of them has to do with transgender discrimination. So what they found today was, and the opinion was authored by Neil Gorsuch, who is typically a conservative. What they found today was that sex, as defined in Title VII, the 1964 Civil Rights Act, also embraces discrimination based on sexual preference. And basically, Gorsuch relied on the actual text of the legislation itself instead of looking to legislative intent or legislative history as urged by Trump's attorneys in the Solicitor General's office.
How big a leap forward is this legally? The idea that racial minorities, genders are forbidden from being used as a basis for employment discrimination has been around since these statutes were passed, but it had been pretty consistent through a lot of decisions at the federal level that sexual orientation was not on the list of protected classes. So how big a deal from a practical point of view is this ruling?
Well, it's a big deal in some states and not in others, because most of the employment discrimination laws have state versions of the same thing. And over the last couple of decades, there's been a transition in states to outlaw sexual preference discrimination. By way of example, in 1999, I had one of the early transgender cases. They were very rare back then because there weren't as many transgender operations at the time. I was representing Bell Atlantic, and I was defending. And what I found was there was a city statute in New York City that outlawed sexual preference discrimination. It did not outlaw transgender discrimination. The person was born a he and was in the process of transitioning to a she, utilized that statute. There was no state statute, and there was no federal statute to protect sexual preference or transgender. Since that time, when I prevailed in defending that case, there's been, over the last decade, just a real change in favor of protecting sexual preference. And in addition to most of the Northeast states protecting it, a lot of companies also list in their policy that sexual preference discrimination is outlawed. And then that policy can be enforced under, implied breach of contract kinds of arguments. Mm-hmm. But the sexual preference laws in a place like Connecticut or a place like New York, what happens is that employees always sue under both the federal and the state statutes anyway. So they don't really lose anything by not getting the federal protection for sexual preference because they have the state to fall back on.
So it
now,
sounds
in a state like
this
Connecticut,
is probably the biggest deal for people in more conservative states who didn't have a red state, a southern state, who haven't had the state protection to fall back on. Yeah.
Right. So, for instance, the 2 of the cases, one from the 6th Circuit and the 2nd Circuit, the more expansive reading of Title VII was upheld. And the 2nd Circuit, it was an en banc decision by the 2nd Circuit saying that Title VII actually does protect sexual preference. In the 11th Circuit, the lead name of this case is Bostic, and that was actually from the 11th Circuit case, and that came out of Georgia. And in that case, they found that there is no state, there's no state protection of sexual preference there. So you really had to proceed under the federal. There are, like in Connecticut, for instance, one of the reasons that I sue, I'm now on the plaintiff side most of the time. The reason I, representing plaintiffs, sue under the state, the federal law, in addition to the state law, is because punitive damages under the state law is capped at attorney's fees, where under the federal legislation, I can get both punitive damages for my clients as well as attorney's fees. So, extra money for them, another $300,000 under the federal statute. So
this
it is important.
This strengthens plaintiffs' hands even in blue states in that way.
Correct. Because, Connecticut is rare. Like New York doesn't cap your punitive damages by saying it's whatever your attorney's fees are. So even in blue states, there's a benefit oftentimes to proceed under the federal law, but also just in terms of from a normative perspective, to finally have the Supreme Court of the United States say that sexual preference as a matter of federal law is protected. And then beyond that, I mean, there are a lot of cases that I've seen over the years regarding sexual preference. Transgender cases are rare simply because far fewer people are transgender than are gay. But this is enormous for transgender people too, because it makes them feel like they're human beings, right? I mean, it makes them feel protected under the law. It has a moral value, a normative value, a resonance in terms of for emotional reasons as well.
And that is why you're seeing such an outpouring today. I've seen in media, social media. This is a big deal. Kristan, let's talk about the makeup of the majority here. Justice Neil Gorsuch wrote the majority opinion. He, of course, is the justice who took Anthony Scalia's place on the Supreme Court, and that was a moment in time. His between his appointment and also the fact that other justices came onto the court who were not seen, especially when Anthony Kennedy retired, the loss of that seat for the gay progressive community was seen as a major loss because, of course, it was Kennedy who wrote the decision in the case upholding gay marriage. And it turned out not only did Gorsuch end up being an ally of the gay community in this case, but they had Roberts as well. So it was a 6-3 decision. How much did it surprise you, and was it a surprise in general, that Neil Gorsuch ends up writing a decision like this?
Well, when I read it, I was surprised, but it is consistent with what he promised to do when he was being interviewed for the congressional hearings, when he's being interviewed by Senator Feinstein. He said he was not going to look at the intent of framers, so the example there was the 14th Amendment, and he said he was not going to look at the legislative history. He was always going to elevate the actual text, that he was a textualist, and he would elevate actual text over legislative intent or legislative history. So here, the president who appointed him, Trump, his Solicitor General was arguing that one should look at original intent, not original intent, but legislative intent and legislative history, and that back in 1964, folks were only focused on gender, and certainly not, they didn't intend sexual preference to be embraced by Title VII. But Kagan very masterfully took Gorsuch's commitment to textualism and used it against him in a very, very skillful way. And a lot of court observers were predicting back in the autumn that Gorsuch was coming along to Kagan's view, and that Kagan was really the one who was using his commitment to textualism against him to make very powerful arguments. And people like George Will were commenting that she's very, very shrewd at doing it. I mean, she was a professor at the University of Chicago, which is Scalia's former stomping ground. It's the most conservative law school in the top 10. And so she's very skilled at using some of the right-wing arguments against them by taking textualism and bringing the justices along to a more progressive goal. So I think we have Kagan who did a lot of the heavy lifting here, and she brought Roberts and Gorsuch along.
What do you think the implications are for other cases that might come before the court that Neil Gorsuch has shown this flexibility, this willingness to move to the other side of the ideological divide on the court, side with the liberal justices along with Justice Roberts? Are there other areas that you can think of where this textualism, perhaps, as you say, could be used against him or against perhaps his political or previous political instincts to deliver a result that progressives might cheer?
Well, if you want, I think that if we look at Kennedy and where it was that Kennedy went along with the progressive wing of the court, that would probably be the best indicator that one would have of where Gorsuch would go. If recollection serves, Gorsuch was a clerk to Kennedy, and when I've seen him give speeches to students and other legal scholars, I think it was at a law school, where he praised Kennedy as being just this extraordinary man for whom he had the greatest respect. And we know that, for instance, the Defense of Marriage Act decision was written by Kennedy, and that provided rights for gay people. And it's interesting that on this first case where Gorsuch has proven himself more willing to think progressively, it's also on a gay issue, a la Kennedy. So I think that's those kinds of cases where Kennedy was siding with the progressive wing of the court may be the same kinds of areas where we'll see an element of progressive decision making from Gorsuch.
Justice Alito, in his dissent, was not surprisingly critical, even scathing at times in his critique of the decision, essentially saying that the majority was legislating, that they were going far beyond the intent of of Congress when they passed Title VII, which was in his mind was meant only to deal with gender and not with sexual orientation. He went so far as to use the name of the late Justice Antonin Scalia, whose seat Justice Gorsuch occupies, in essentially saying this is not what Scalia would have done. I thought that was really interesting, the way that Alito specifically called out Scalia in his dissent.
Well, Gorsuch never said that Scalia was the justice upon whom he would be modeling himself. He really has said it's Kennedy. So, but Alito obviously thinks that Scalia is the one who was the thought leader for conservatives on the bench. Scalia was, as you and I've discussed in the past, he could have a commitment to an analytical construct on issues like the First Amendment, but when it comes to things like this, he proved himself to be very, very Catholic, and I don't think that he could see his way. He probably would not have been able to see his way to be writing an opinion that sided with Roberts and with Gorsuch. But I don't know why, Alito obviously thinks that Scalia is the torchbearer for the Conservative Party, but Gorsuch signaled before that he really sees Kennedy himself more in the mold of Kennedy. So it's very interesting that when you look at the makeup of Catholics, I say this because I'm born and raised a Catholic myself. But Catholics have been fairly conservative on this issue of sexual preference and homosexuality. And 3 of the justices who voted against extending Title VII to gay people are Catholic justices, but another 3 Catholic justices voted with the progressives. So right now, Catholics dominate the Supreme Court. I think there's 6 out of the 9 justices, and there was a real split amongst the Catholics on the court as to what to do with on this issue. I would say that with respect to Alito's argument that that Gorsuch was legislating because the original legislators had not intended to embrace gay people in Title VII, I think he completely misses the philosophical point. The philosophical construct to which Gorsuch has made very clear he is committed, which is to elevate text over legislative intent and legislative history. So it's almost like he's spitting in the wind making that argument, because Gorsuch has basically said to him, that's exactly right. I'm not going to look at their intent. I'm not going to look at legislative history. I'm going to look at the actual text. He said that in his hearings. He said for the 14th Amendment, I'm going to look at what the language of the 14th Amendment actually is, which is that everybody, all men are entitled to the equal protection of the laws. And he made the point to Feinstein in those hearings, you know what? Everybody who was voting in the 1860s on this issue was probably a racist and a sexist. I'm not going to look at what their intent was. I'm going to look like what they said. The words on, I think he actually said the words on the building of the Supreme Court refer to equal protection under the laws. And that text is what I'm committed to. So I think Alito completely missed the point of what it is that persuaded Gorsuch. Kagan, in contrast, understood, and that's why she ended up being the better negotiator at these judicial conferences on the issue.
All right. Well, quite a day indeed for the Supreme Court. History making for sure. Kristan Peters Hamlin, thank you so much for joining me to break it down. Appreciate it.
Thank you, Rob.